Good evening to the participants of the SLW616, that is Law and Economics. Karibu sana. Welcome to my class. Participants, anyone can unmute and read what I posted on the screen. Participants, anyone can unmute and read what I posted on the screen so that I know that you are with me and you know that I am with you, and both of them traveling in the same train to reach to the destination. Yes, it is a thought law, and we are dealing it and economics interest. And in our yesterday class, we taught how it can play an important role, and which is the best method to whether to eat tomorrow chicken or today egg. Okay, now let us see that examines the tort law. Economics examines the extent to which the law of torts provide protection against the actual or potential loss of wealth. It examines the concepts, principles, and interconnections of tort law and discusses how the legal principles are related to the actual activity of the wealth creation and preservation. That is Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, South Monza, Tanzania, East Africa. Then, without wasting the time, let we go to our class where we stopped yesterday. And yesterday we stopped here. I put the asterisk mark here. Where I put the asterisk mark? Tatla. Yes, here the asterisk mark. See, you could see it, which I highlighted here. Asterisk, you say, don't say star. So, tort is a part of the system of private law and is enforced through the private actions. It is a private law. The economic analysis of tort law has stressed the issues such as the distinction between the negligence. A party must pay for the harm only when the party fail to take the adequate or efficient precautions. That is the full negligence, contributing negligence, common negligence, depending upon the how much the percentage will be in, you will be contribution will be there for the negligence or for the accident, that much will be deducted. So that we will say in my yesterday class, that is the contributed negligence. If you don't wear the helmet, how much the percentage will be deducted? Fidelis Kitange. And you give the answer also. Sir, it is 20%. Okay, when 20% will be deducted over there out of 100, how much that you are going to get it? 100 minus 20
20,
is called
80.
80. We are going to get it because your contribution is 20%. And strict liability, a party must be paid for an injury caused by its action. A strict liability example which I have given is Mafuta ya Nivele, hair oil. Example which I have given is a manufacturer prepared the hair oil and one of the customer used the hair oil and he became a kipara. I asked the what is the kipara in Kingereza? Hurry up.
Pass, Professor.
Bald, B-A-L-D, bald, B-A-L-D, bald head. So he became a bald head. All the hairs are gone because of the oil. The oil is not that much appropriate. It is eaten away the scalp, eaten away and cut the and hair falling would be there. Then he will file a case against the manufacturer for the strict liability. And in the strict liability, he says, of course, there are 5 exemptions are there for the strict liability, but now the concept of the strict liability is changed into the absolute liability. Do you know what is the distinction between a strict liability and absolute liability? Answer either you say yes or no or pass on.
Pass on.
Strict liability always have the 5 exceptions, but the absolute liability doesn't have such an exception. The absolute liability concept has come in the world. I am saying in the world, W-O-R-L-D world, by the one case law, which is from India. Can you tell me the name of the case law? It's a world famous case law. Every person
I
who
forget.
reads the chart should know the case law. I told you, if you know it, you tell me. If you don't know it, you say pass on.
Pass on.
Unless until I will get the answer from you, I don't give the answer. That is the case law is MIC case law, Bhopal gas tragedy case law, Union of India versus Union Carbide case law. Have you heard the names of the case law anytime?
Yes, Prof.
Tell me what you heard.
I didn't get you clearly, but I think at future time I'll Google it and find more detail about it, Prof.
It is called Bhopal gas tragedy case law. Or you can say MIC case law. MIC means, what is MIC?
Okay.
What is MIC?
Pass on.
Methyl isocyanide case law. Methyl isocyanide case law. That is the MIC case law, not this MIC Tanzania Limited versus Hamisi Munyanjo. Munyanjo. Excuse me. MIC case law also be known as Bhopal gas tragedy case law. The Indian judiciary brought the fair justice to the victims on 14th and 15th February 1989. The Supreme Court Union Carbide Corporation versus the Union of India ordered the UCC to pay a sum of dollars 470 millions, that is rupees 750 crores, to the victim. Bhopal gas tragedy case law. That is the MIC case law or Bhopal gas tragedy case law or Union Carbide Corporation versus Union of India case law. It is a remarkable case law, and this case law made the concept of the strict liability into the absolute liability. Read this one. I said read, which I highlighted.
Sorry, Prof. My phone has no charge and it's about to shut down. I have only 12 percentage. And now it's only audio that's what I can see. So I can use only audio.
You know, you don't have backup power.
And my phone it's having only 12 percentage. I don't have bank power. And probably we were not sure that if we are going to have session today. That's why many of us,
I
many
posted
others were not
in
sure.
the WhatsApp group that yesterday I took the 2 classes, but today I will take only one class. Again, I told you, no, I don't know who are the people learned economics and who are the people in intellectual property law. Whether the people
The
are the
problem,
same or people are the different.
the problem, Prof, is some of us we don't get WhatsApp activated every time. So it's happened only if a person have visited WhatsApp, then he
Why
get the
don't you see
notification.
the group WhatsApp? I posted in group WhatsApp the entire the 3 courses. Did you see it? Sorry, sir, I did not
In
see it.
myself, I saw everything that you posted in our group WhatsApp, but
When you saw it, why
I
did
think
not you pass on to your friends?
I tried to send them normal text, but they didn't. I didn't get any reply till now.
And nobody
And I will.
cares.
And
Is it the same phenomena? You don't go to the classes?
I will go to the classes as usual. But today, we think that because yesterday we attended the 2 session, we were not sure that if today we are going to
Did
have
I
another
say?
session.
Did I say?
You didn't say, Prof.
Then how could you presume?
Uh,
If I don't take the
ah,
class, I will inform in advance. If I don't inform you, presumption is that today class is there.
mm,
Okay, doesn't matter how much the time would be there, you will run it, otherwise I will continue it. This article deals with the analysis of the noteworthy oleum the gas leak case law, in which the Supreme Court established itself the protector of the Article 21 of the public rights by adopting the principle of absolute liability. So, absolute liability has come into the force from the oleum gas case law and the MIG case law. The concept of the strict liability will be changed into the absolute liability. In the strict liability, there are the five exceptions, but in absolute liability, there are no exceptions. Is it clear?
clear.
So, in the strict
It's clear.
liability, the manufacturer has to pay the compensation entirely, the medical expenses, or till he gets his hairs back. So there is no exceptions for there. There is no contribution of the customer, I mean client or consumer. So generally, whenever the product would be there, like a hair dye, nivele rangia nivele. And they say that you make a test first by keeping some solution behind your ear. If you get the itching, don't use it. If you don't get the itching, you can use it. And such is there in the brochure. And it shows how it can be used. And it can also shows the composition of it in the different languages, which is in the box. So the strict liability concept here there, and because the most accidents are caused by a joint action of injurer and victim, the driver goes too fast and the pedestrian he hits does not look carefully. Efficient rules create intensity of the both the parties to take the care. Most negligence rules are negligence with the defense of contributory negligence or comparative negligence or common negligence. Create exactly these incentives. Strict liability is important when the issue is not only the care used in undertaking the activity, but also whether the activity is done at all and the extent to which it is done, the level of the activity. Highly dangerous activities, blasting with explosive, keeping wild animals as pets are generally governed by the strict liability. Can you keep in your house Simba as a watching dog?
No, it's not possible, Prof.
Why?
Because it's a dangerous animal. On the list, otherwise, if you have a special permit from the authority concerned,
Do
and
the authority
probably
will
they
give the
will
permission to keep the Simba as a dog in your house?
not as a dog, but I think in some instance when we were studying taught undergraduate, we were told that there are some instances if such a Simba is taught and has been maybe kept in a way that does not hurt human being, under such circumstance, the person can keep Simba. But even there are some instances when the Simba uh, changed or have passed through some instance and hurt human being, that means you are going to be liable to that aspect.
Strict liability
But
concept will be applicable. Number one, the lions are not a
mm,
pet animals. They are not supposed to
sure.
keep in the houses. The government will not give the
Mm,
permission to keep in the houses the lion. You can keep in the house the dogs. And that to be, you cannot keep the 100 dogs in your house to watch your property. because it creates a nuisance. So, domestic animals are allowed to keep it in the house, but not the wild animals. And the lion is a wild animal, and hence it could not be kept in the house like you are keeping the dog, even to protect your own property. So that is the thing which is given, the dangerous things and explosives. Can you keep a revolver AK-47 in your house? Answer is you have to apply for the permission to keep why you want a particular rifle or revolver or AK-47. If your life is at threat, at that instance, you have to write to them that life is threat because many people will try to chase me and want to kill me because I'm a tycoon, business tycoon, and hence the government will allow them to protect explosive materials like revolver and guns will be provided over there, and not the machine guns. Only the AK-47 if it is possible over there. Otherwise, the revolver is given 12 rounds revolver or magazine loaded revolver. It may have the 13 rounds, 12 rounds, or 24 rounds, depending on the magazine you load in it or the size of the bullet. So, explosives, you have to have the permission because if they escape it and causes injury, then it is you under the strict liability, LL liable to pay because no one can accumulate anything hazardous in his own land. If it is escaped by any other means, you cannot say that I tried to make all the precautions, but still it is escaped. No, it is you who are the responsible because it is the strict liability will come into the picture. Tort law used to an interesting and an important dealing largely with the automobile accidents, but it has become a quite important in the United States or the developing countries or any other country where the law is well developed. The last 50 years, because many events in traditionally treated under the contract law and now they're subject to tort law because people know their legal rights that if anybody wants to violate these legal rights, he can go to and tap the door of the court. For example, in products liability and medical malpractice cases, the parties have a pre-accident relationship and so could have specified and traditionally did specify in the contracts that damage would be paid in the event of the mishap. In the medical negligence are concerned, or product liability is concerned, a strict liability concept will come out. But since about the 1950s, the court has refused honor these contracts, treating these instead of a tort cases. For instance, how could you know that it is a tort case? How could you know it is a contract case? Participants, how could you know it
Yes,
is a
Prof.
contract case? How could you know it is a tort case?
Depending on the circumstances of which a case, whether there are some sort of negligence or whether there is a breach of some maybe terms of existing contract, then the material fact of the case will determine this should be a tort case or should be a contract case.
What is the landmark case law to make the distinction between the contract law and the tort law? There are two landmark English cases are there. One is say about the contract, another is say about the tort.
Maybe I can remember the famous case of Donoghue case.
That is a tort case.
The
That is a
yes,
development of the negligence case. Donegal versus Stevenson. How a
yes,
tort is
Prof.
developed. That shows.
I didn't get you proper.
Donegal versus Stevenson. How a negligence developed from one stage to another stage. Negligence has developed in such a way if a party can file a suit even though he is not party to the contract. That is given in the Donegal versus Stevenson, and the case law says a consumer, a fancy consumed the what type of the beer?
I don't remember the type of the beer exactly, but what I remember, the beer was contaminated with a snail.
What type of the beer
It
it
was
is? Imbegu
also
beer, Meva beer, barley beer. It is a ginger beer, Tangawizi. It is a ginger beer. She poured in the tumbler. She consumed it. Next time she poured in the tumbler. Then she found a rotten snail in it. By looking the rotten snail, she developed the nausea and she vomited, got unconsciousness. And his lover taken her to the hospital where she was admitted. After 2 or 3 days later, he filed a case against the manufacturer for the negligence. The manufacturer told that you are not the party to the contract and hence you cannot file a suit. And the negligence has developed in such a way, if any person consumes the product and he will be the second party. The first party is the party who manufactures the product. So there is a chain is there from the manufacturer to the distributor, distributor to the agent, agent to the retailer, means pub owner, from pub owner to the steward or waitress, from waitress bringing to the table of the consumer. So this is a chain is there, and the bottle which is manufactured in the company, the same bottle is brought on the table of a customer and the bottle is opaque, it is not yet transparent, and hence one cannot observe in the opaque bottle the rotten snail is floating over there. So the waitress opened the lid in front of the customer or consumer. That means chain is not broken. Novus actus intravenous, that is the Latin terminology. No new interference has come out and hence the chain is not broken. And the consumer, when he consumes it, and the goods are, it should be in a consumable nature. If it is not worth enough to consumable nature, the product should not be sold in the market. A quality control should have to test it before the product will come into the market, and they failed to do so. Hence, negligence on the part of the manufacturer, and hence the consumer will be entitled to get the compensation even though the consumer is not a party to the contract. That means privity of contract become a fallacy. That is the number one principle. Number two principle, who is your neighbor? A person who consumes the lost one, he is your neighbor. So you should have a contract with your neighbor. That means already contract is implied contract, it is there, and hence he can sue it. Moreover, the product which is produced by you is not worth enough to consume, and hence negligence has occurred by the product producer. So that is the whole story of Donegal versus Stevenson. But I said that law of contract, remarkable and landmark case law is Jennings versus Randall. Spelling Jewning. Jennings versus V full stop Rundall Rundall. And this case law it is a contract case law. And here they have taken a mare for the riding. What they have taken? Mare for the riding. What is meant by mare? Participants. Kitange.
Yes, Prof.
Say Pasan.
Person. The problem is currently I don't know if there are more participants or less because I have only an option of using an audio mode only. I cannot see whether there are more participants or no. So that's why sometimes I'm taking time to listen whether there is any person who is going to respond or otherwise.
See, with that view only generally, I will share my file. Jennings versus Randall is a landmark case law regarding the law of contract. Here it is given. What is that given? Read. It's running, buffering. Can you read it now? Is it visible to
Prof,
you?
Prof, I cannot read anything on my screen. I have only an option of listening an audio because of
Okay. Because the
get to
purpose of
charge.
my
So
sharing
I can
is
only
you can
listen
see
and
on your
talk. Yes,
smartphone.
Prof.
You can see on your laptop. You can see on your desktop. And we can easily go through where I am studying, where I am reading, what I am explaining. And the cursor, could you see the cursor even? You don't see the cursor, which I highlighted. Did you see it?
And I only see an option of muting and unmuting. That's all what I have in my screen. I'll be screenshotting and post it to the group later. Then you
Is
can
the
see what
Jennings
exactly
versus
was.
Randall
And I
is a
think there is no
1799
power.
case. Okay, okay. I am reading. I am reading. Don't worry. Jennings versus Randall in 1799.
Professor,
I said, you listen. Yes, you do want to ask anything, Hamis?
um,
Anyone want to ask any question, please?
no, I
Anyone
don't have
wants to
question.
ask any question? Or shall I proceed?
I don't want to ask any question. Rather, I want to read as you instructed.
Say loudly, keeping near to your gadget. Speak loudly, keeping your gadget near to your mouth. Shall I proceed?
Yes, proceed, Professor, proceed.
I appreciate. Jennings versus Randall, it is a 1799 case law where M is a minor. A minor hired a horse for riding and injured it by excessive and improper riding. And here they say horse, but actually it is not a horse, it is a mare. Mare. What is meant by mare? If you know it, you tell me. If you don't know it, you say pass on. Siokimia.
Can you repeat the question, please?
What is mare? M-A-R-E, mare. Unmute and speak or say pass on.
Person.
I appreciate. Mare means female horse. What is male horse? Mare means female horse. What is male horse? Say, pass on.
Person.
Stallion. Stalion. You know the Hollywood actor Sylvester Stallion. Rambo.
Yes. Yes, Rambo, Sylvester Stallone.
Yes, stallion, the same stallion spelling. Stalion. It's a male horse. Okay, now M was not liable in tort for negligence since all he did was an act contemplated by a contract, that is a riding. It is not a tort law, it's a contract between a minor and the horse owner, and he has taken the horse for riding, but he has used for excess riding. With that, the horse got injured, and it is a contract, it is not a tort, hence the minor is not liable. A minor may, however, be made liable in tort if act is of kind not contemplated by the contract. So, what is not contemplated in the contract, we can say it is a tort. Now, this is the one case law where we can say that a minor cannot be a party to the contract, a minor cannot be sued. Am I right? Am I right? Say yes.
Yes.
You have to give the answer so that I could know that you are with me. That is my intention. So,
Person.
Bernard versus
It's because
Huggies.
of network. Today network is not proper.
Yes. Repeat. Hamis, repeat what you said.
I say today's network is not proper because of the weather.
Sometimes you say weather, sometimes you say amna data, sometimes you say amna hela, sometimes you say nja. So now, Bernard versus Huggies. Could you see the case law now on the screen? Hapana, say.
Yes.
Bernard versus Huggies is the case law. There a minor hide a mare. I told you no mare. Mare means mare means
Female.
appreciate, appreciate. Very
Female.
good, very good. It was expressly agreed that the mare will be used only for riding and not for jumping and larking. It should not be used for the jumping and larking. The mare was made to jump over a fence and she was impaled and it and killed. It was held that the minor was liable for the negligently killing the mare as his act was totally independent of a contract made by him. Hence, it is not a contract, it is a tort because in the contract it is clearly mentioned that he should not be used for the jumping and lurking, but he disregarded the condition and used the mare for the jumping and lurking, and with that the horse became tied and became impaled, and lastly the horse died. So it is a tort, not independent of a contract, hence a minor is held liable. Is it clear? Say yes.
Yes, Professor.
Say no.
Yes. Not no. Yes.
This is you studied in the LLB. the distinction between a contract and a tort, a Molimo definitely will say this Jennings versus Randall case law, which is purely contract, and where the Bernard versus Haggis case law, it is a purely a tort, because even though there is a contract, but it's not arising from the contract, it is negligence part is there, hence it is a tort. So that is the cases we have to study to know the distinction between the contract and tort. So here we can say, where we are here, yes, tort law. The courts have refused to honor this contract, treating those instead as a tort cases. Many observers believe that this was a fundamental error of the courts to look on it as a primary example of an insufficient doctrine in a modern American law. Scholars have found that his error was caused by action on the part of the plaintiff's bar, who were seeking a benefit themselves at the expenses of the public in general. Problems are exacerbated when claims are aggregated through the mechanism of the class action. So this is nothing but, in certain cases, even though he is not a party to the contract, he is not the aggrieved by the action, but still one can file a case in the court of law on behalf of the victim. What type of the case it is? Participants, give me the answer. Sir, what is the question? Question is, he is not a victim, he is not a party to the contract, he is not even a relative to the victim, but still he can file a case on behalf of the victims in the court of law. What is the type of the case? If you know it, you tell me. If you don't know, you say pass on, but don't waste the time.
Just representative suit.
It is a public interest litigation, or we can say class action suit.
Professor,
Yeah.
how come is it public interest litigation rather it is individual interest?
In the public interest litigation, a person who files a case need not be a party to the contract, and a person need not be a victim to the situation. When public at large will be suffered, you studied what is that Belagele municipality case law, Belagala, the dumping of the Takataka. Have you read the case law? Have you read the case law? Answer is yes or no.
Professor, which case? Which case?
Takataka dumping case law.
No, no, not yet.
Belagade, Belagele case law. I will tell you what the case law name is. Dumping the garbage, garbage in Dar es Salaam area. This is the case law. See, this is the case law. Disposal of the case, solid waste in the Dar es Salaam. I don't know why this is not given Dar es Salaam case law. Yes, repeat the case law name. Yes, that is the case law. Disposal of the garbage, he need not be a person, he can be any person who can file a case on behalf of the victims. That is the case law. So there is a public interest litigation. One can make it out because other people will not having that much money to file the case, and hence this man come forward to file the case. And I told you also the environmentalist and who filed many cases in the environmental law in India. Who is that advocate? Name? Even oleum gas case law also he tried it. MC Mehta versus Union of India. Mahesh Chandra Mehta versus Union of India, and many public interest litigations were filed in India on behalf of the victims or the people who suffered. So here, two factors have caused a major expansion of the product liability law. One was finding relatively strict liability for a design defect. There are three defects should be there in the product liability. If you really study the product liability, you are supposed to know what are the three defects. Can you tell me? One is a design defect. Second, asante sana sikiliza darasa. Mungu akubariki na kukulinda.